Thank you, everyone, for joining us in the third table of the day. On this occasion, we're going to have Professor Diego Papayannis with a presentation about tort law without interpersonal justice, a comment on Gregory Keating's reasonableness and risk. As the previous tables, you're going to have 30 minutes, and then we're going to have time for Professor Keating's reply, and then we will open the debate to the rest of the assistants. So, your time, Professor.
Okay, thank you. Good afternoon to everyone. I have prepared some critical comments on Greg's latest book. But before going to the comments, I want to express that I share a lot with Greg Keating's insights. I mean, I learned a lot from his work over the years, and these kind of disagreements can be understood as a domestic disagreement between two persons that tend to see things more or less the same when it comes to the fundamentals of tort law. So I will not focus about those parts on which I agree. I will mention which parts I agree, only that tort law is part of the basic structure of society in rules and terms, and that it protects central interest in personal security, which is a primary good, right? A good that is useful for any plan of life you want to pursue. You need some personal security to be free of the interference of other persons in your own life. And harm is a typical way of interfering with your life. I also agree that a lot of tort law has to do with interpersonal justice, and so, as Keating, I endorse a pluralistic view of tort law. It has to be understood, taking into account its purely private or corrective justice aspect, and also its distributive justice aspect. But as any pluralistic theory, Keating's theory faces some challenges and is to provide an articulated view of those dimensions. What I'm going to say is two things. That the first is that the theory, in a way, diminishes the contribution of interpersonal justice in justice writ large. This is how we call it, the general idea of justice. And also that Keating's view, specifically of strict liability, misrepresents in a way what interpersonal justice is about, or how it regulates relations between individuals, between people. Okay, let's go with the first line of criticism. The idea that the view of strict liability that Keating endorses is distorts in a way interpersonal justice. This is the first thing I will comment. According to what can be understood as a standard view, tort law has two aspects. One is a guiding aspect or regulatory aspect, and this aspect consists in the fact that the parties are under an obligation to respect the other's rights. I mean, they have a duty not to harm others in certain ways, in certain circumstances. It's not an absolute duty not to harm. It's qualified depending on the circumstances. Sometimes we have a duty not to harm by omitting reasonable precautions, and sometimes we have a duty not to harm only intentionally. For example, in sports, we don't have a duty not to harm by negligence, only by intentionally inflicting the harm. And there is a second aspect, which is a reparatory aspect, that is that when the guiding aspect fails, then liability is triggered to correct the unfair or unjust interaction between the parties. So, according to this view, the normative structure of tort law has two levels: a primary level and a secondary level. The primary level is a right not to be harmed that is correlative to a duty not to harm in the same circumstances, and a secondary level that is the compensatory level. That's the duty to pay compensation once you violated the primary rule, the primary norm, and that is correlative to to a right to recover damages. Okay, this is standard view in the deontological theorists, but I think Keating does not endorse this view fully. This is explicit, I think, in his treatment of strict liability. According to Keating, in harm-based strict liability, the wrong is not to cause harm, but failing to pay for the harm justifiably inflicted. So the wrong is not to harm, is not paying for the harm you caused in some cases of strict liability, which is a broad category because it includes enterprise liability, abnormally dangerous activities, includes a lot of things there. And the example he provides is the Boomer versus Atlantic Cement, for example, among many others. This is one case in which a cement plant pollutes the neighbor, and it's obvious that this result is going to be produced, but we think that the production of cement is a valuable activity, should not be stopped, should not be required to stop. There is nothing wrong in that, but we attach liability anyway. We make the producer of cement pay for the damages it causes to the neighbors. And I think here Keating distributivist perspective collapses the activity and what I call the statistical consequences of the activities. And this misrepresents, as I previously said, interpersonal justice. What Keating assumes is that if we want the activity, we want the production of cement, then we must tolerate the characteristics risks of that activity and also the resulting harm. As I see it from the what I call macro aggregative perspective, this is correct. I mean, in general, you cannot have the activity without the harmful consequences. But from the interpersonal justice perspective, the harm wrongs the victim's rights anyway. After all, some innocent party is being polluted by your productive activity. Okay? And by insisting that the activities subject to strict liability should not be stopped, I think Keating misses that the relevant description of the activity sometimes excludes its harmful results, as we previously discussed in Jenny's presentation. To say it very briefly, the blasting, when you have a controlled blasting to demolish a building in ruins, the blasting should not be stopped. By killing other people in a blasting is wrong. That should be stopped. So even if blasting is a valuable activity in certain conditions, harming in the context of a controlled blasting is not something we should not stop or we should tolerate. The same with cars. In Spain and many other countries, driving is subject to strict liability. According to this view of strict liability, drivers do not have a duty not to harm others after they took all reasonable precautions. But I will distinguish driving and the statistical consequences of that some pedestrians are going to be hit by cars. And I will say, well, driving, there is nothing wrong with driving. Driving should not be stopped. But hitting other pedestrians while you're driving is wrong. You wrong the plaintiff in that way. Another example that Keating provides is the sailors in shore leave. Sailors in shore leave, when the ship gets into the port and you give some free days to the sailors to spend some time and relax and get recovered by all the stress of being in a ship confined for so many days. Sometimes they drink too much and they harm other people. Okay. So according to Keating's analysis, the Coast Guard, for example, or the shipping company or whoever, is not under duty not to harm through its sailors. And in a way, it makes sense to say, well, they are not acting. They're the sailors who wreak havoc. They destroy other people's property or they get into fights. It's the sailors. It's not the shipping company or the Coast Guard. But in a way, I would say that the shipping company or the Coast Guard has a duty to guarantee that their sailors, while they're in a shore leave, will not hurt anyone. They will not misbehave. If you say that it is impossible for them to make sure of that, then I will reply that the same happens with all negligent drivers. It's impossible for negligent drivers to guarantee that they will never get distracted behind the wheel. But why is this analogy important? Because we couldn't infer from that fact that drivers are not under a duty not to harm, even if it is impossible for them to prevent this kind of harm. Another concern is how Keating's view of strict liability is compatible with another thesis that he sustains along the whole book, that is that the priority of rights is better to protect rights than to compensate for the harm you cause. But in strict liability torts, it seems that the priority of rights is not there anymore. It doesn't hold as a thesis. Okay? And finally, another aspect that made me that raised some concern is why my physical integrity will be dependent of the kind of activity you decide to undertake. When you drive a car in the United States, you owe me a duty not to harm by failing to take precautions. But when you sell me produced food and you are under a strict liability, you don't owe me a duty not to intoxicate me with your food, if you took all the reasonable precautions. I mean, why should my right not to be harmed be dependent on which activity you choose to perform? Another aspect is in which this has a bearing, is his view of enterprise liability. In the analysis of enterprise liability, Keating argues for a kind of a principle of collective responsibility, because all the defendants or all the parties in that enterprise create the same kind of risk, so they're covered or they're reached by the same principle of collective responsibility, and this recommends spreading among many people, probably through insurance mechanisms, spreading the cost of those accidents. And in order to support this idea, he uses Waldron's example, the fate and fortune example. The fate and fortune example, to make it short, is that two people are committing the same negligence, but one harms another person and the other one does not harm. So according to one description, Keating says, fate, who is the one who causes harm, does exactly the same thing that fortune, but fate, is unlucky because he causes harm. But harming, in a way, is beyond its control. This is the idea. On the other hand, if you pick a different description that emphasizes individual responsibility, you will say that fate does something very different from fortune, because harm is like a normative significant consequence and defines the kind of action that the person does. The interesting thing is that, according to Keating, both interpretations seem plausible. They are both acceptable. But I think that they should not be equally acceptable if, as Keating says, and has a specific part when he analyzes Fletcher's theory of race, reciprocity, and the context, etc., where the main point is that the central concept in tort law is harm, not risk. If you are committed to this idea that the most important concept is harm, what has normative significance is harm and not risk, then fate and fortune does something that is quite different from what the other does. Fate does something different because fate hits someone with her car, and fortune does not. Okay? Additionally, if Waldron's fate and fortune example is a good example to illustrate collective responsibility, then collective responsibility does not exclude the existence of a duty not to harm. Why? Because it doesn't seem that fate is only under a duty to pay compensation. I mean, the argument is, look, in this kind of cases, both generate the same kind of risk. What is important is collective responsibility. Yes, but in these kind of cases, I would say that fate has a duty not to harm anyone by failing to take precautions. What happened in the case? They both failed to take precautions, and if this is a case of collective responsibility, then collective responsibility is compatible with having a duty not to harm. And the most important problem, finally, I think, is that enterprise liability, as defined by Keating, should also apply to systematic negligence. If you think of many cases of systematic negligence, they take place within valuable activities. Keating, in some part of the book, says if you produce enough bottles of Coke, some of them will break and harm some of the consumers. If you, I don't remember all the examples, but if you do enough blasting, some blasting will go wrong. If you transport enough gas in how we call the gasoline in tanker, yes, thank you. Some tanker trailers will explode. And I will add now, if you do enough driving, some drivers will get distracted. And if you do enough curing as a doctor, some patients will receive the wrong treatment. So what prevents us to see systematic failure to take precaution, systematic mistakes, systematic negligence as a case of enterprise liability where there is no duty not to harm. No physician can guarantee that he will not or she will not commit any mistake during the whole life. Okay, but it doesn't mean that when they give the wrong treatment to the patient, they do not do anything wrong. Of course they do. So I don't see why strict liability should be represented as not involving a duty not to harm. I think it's compatible to see in enterprise liability that there exists a duty not to harm. Another line of criticism is that Keating's theory might have some problems accounting for what in this literature is called the correlativity requirement. I think Keating is right in criticizing the advocates of corrective justice, such as Weinreb or Ripstein, for having difficulties in differentiating fault and strict liability. They tend to reduce all cases of strict liability to fault liability, and if they cannot do that, they just point out that those cases of strict liability should not be admitted. Should be expelled from the tort discourse and should not be admitted. Okay, if they don't fit within the fault rule, they are mistakes of the practice and should be eliminated, should be corrected. Okay, this is I agree with that. But I think that Keating own conception drives negligence and strict liability too far from each other. I think that they separate too much. I think that it's possible to give a unified view of fault liability and strict liability as different kinds of rights and duties regarding harm. Strict liability imposes on agents a duty not to harm in the course of their risky but lawful activities. Fault liability gives only duty not to harm by failing to take reasonable precautions. And this is a simple scheme. But this is not the path that Keating takes. According to Keating, both under the fault rule and in cases of harm-based liability, non-fault accidents should not be avoided. In cases of strict liability, as the same as under the fault rule, when the defendant is not at fault, the accident should not be avoided. And the key difference lies in the allocation of the burden. Fault places the burden of harm on victims, and strict liability shifts to the injury. This is the only difference. It is clear victims bear the non-fault harm under the fault rule, because they only have a right, not to be harmed by unreasonable behavior. So they do not suffer any violation of the right. If the defendant was not at fault, the harm cannot be attributed to them. They cannot be made held liable for this harm, because no right of the victim was violated. But under strict liability, if the injurer does not violate any of the victim's right, as Keating claims that there is no duty not to harm, why are injurers obligated to pay damages? This is one thing I wonder. In other words, how can we connect the victim with the injurer under strict liability? To make this connection, now Keating changes his definition of the wrong under strict liability. Before, he said that the wrong was harming without repairing, and now he says that it's benefiting through harming. But I think that the shift is problematic, because if benefiting through harming is considered a wrong, then the injurer should have not engaged in the harmful action in the first place. If now you say, no, the wrong in strict liability is benefiting through harming, if it is wrong, it should be avoided. You shouldn't have performed the activity. And I think this introduces some inconsistency in the theory. And secondly, even if defendants as a class benefit from imposing risk, the defendant is not the only one who benefits from the activity. Maybe the victim benefits, and other potential defendants benefit also. So why does the burden of compensation fall on the particular injurer that by hypothesis did not violate any of the victim's right? I think that the violation of the right that is correlated to a breach of duty is necessary to connect the persons in the particular case. And finally, another problem in Keating's reconstruction is how he sees the sovereignty-based strict liability cases is also, in a way, unsatisfying, at least from my point of view. And the problem is that Keating's assertion that the victim's right and not he takes examples, for example, like violating the patient's consent. The doctor performs a procedure which is beneficial for the patient's health, but then do not ask for consent. And in these cases, Keating says that it is the victim's right, not the defendant's conduct, that does the normative work. And I think this is a problem, because the violation of the right and the defendant's conduct cannot be severed, cannot be separated. Keating's assumption that the conduct behavior in particular case he analyzes, that is Moore versus Williams, is commendable because it conferred benefit to the victim. I think it is unwarranted. From the legal point of view, the doctor had a duty not to touch the patient for other purposes than the agreed ones, and when he did that, he violated the patient's right and he committed the wrong. It's not only the victim's right that does, or what is relevant, that does the normative work, because the victim's right, by definition, cannot be violated if not by a duty that the doctor had towards the victim. So I don't see why you need to reconstruct these kind of cases as focusing on the victim's rights and not in the interaction, which implies always violation of the victim's rights and breach of the correlative duty. Another point has to do with necessity cases. And I think that Keating groups together 3 different categories of cases that should be separated. And this category are lawful harms. The second is justifiable harms. And finally, unjustifiable harms resulting from lawful activities. Lawful harms are not objectionable from any point of view, at least from the legal perspective, I mean. and do not constitute any interpersonal injustice or wrong. And the typical example is the market competition, loyal competition losses that one party causes to the other. This is a lawful harm. Nothing to say about it. You lost some, like we play according to the rules of the game, and you suffer some losses, and what can you cannot do anything about it. Nothing to regret on my side either. Justifiable harms involve infringements of the victim's legal rights and are supported by undefeated reasons, but they impose some sacrifice on the victim anyway. I break your door, or the typical Vincent versus Lake Erie. There is some normative loss there. The property rights of the other party were violated. So they are not the same as market competition. This is obvious. And the final, which is the most problematic, is the strict liability harms that are not backed by good reasons. Harming through blasting is never backed or supported by good reasons. In Vincent, the reasons that the defendant had to tie the ship to the dock were undefeated reasons, considering that only pecuniary damages follow from this action and they can be compensated afterwards, and also that the alternative was to lose the whole ship. Well, taking everything into consideration, it is reasonable to tie the ship to the dock, and the dock owner has to suffer some damages. So there are good reasons to cause the harm in these cases. But in strict liability cases, there are never good reasons to cause the harm. There is not a good reason. There is a good reason to impose the risk on you while I'm driving. For example, here in Spain, where driving is subject to strict liability. But if you want the blasting example, well, there are good reasons to conduct the blasting, to perform to do the blasting, but there are no good reasons to harm someone as a consequence of your blasting. The problem, I think, that Keating's view of liability in necessity cases is it reconstructed as a case of what Calabresi termed market deterrence. He argues, Keating, that the rational course of action in such cases is to minimize losses. And I think that the way he analyzes Vincent overlooks the relational aspect of the duty of care, which requires individuals to take reasonable precautions to avoid harm to others. In necessity cases, no precautions were taken. And maybe you can say, okay, but the reasonable precautions in that case were zero. But I don't think that taking precautions is to do the reasonable thing, period. Take precautions is to do what is reasonable to do in order to avoid harming others. And regarding the dock owner, the person, the Lake Erie Transportation, did not take any precaution. Fault is relational. Maybe it's justified what I did to save my property, but it's not justified in terms of avoiding harm to you. I still owe you a duty not to harm, but when I am under a necessity context, I'm allowed, in a sense, to breach my duty not to harm you. This is the only cases in which I breach my duty not to harm for good reasons. In strict liability cases, there are not good reasons to harm. There are good reasons to impose risk, but imposing risk and harming should be distinguished. They are both different things. In the alternative reconstruction that I favor, or I suggest, it's in a way more homogeneous. And this is, I think, a theoretical gain. You can distinguish when you understand strict liability and full liability, as I did, those rules as imposing different duties not to harm. You can distinguish lawful activities in which neither of the rules were violated or breached. You can understand necessity cases in which the fault rule was breached, but for good reasons. And you can distinguish the cases in which you just violated the strict liability rule because you caused harm, and but it doesn't mean that you should stop or should have stopped the activity. Because the activity is valuable, is lawful. Strict liability is imposed on lawful activities. So why stop the activity if it's a lawful activity? But this doesn't mean from this that it doesn't follow that harming within the lawful activity is right. Okay. And finally, the final criticism I presented in this draft is that Keating's view does not take seriously enough the contribution of interpersonal justice to justice writ large. Let us have a look at Keating's assertion that tort law cannot be understood or justified without considering the interests it protects. This is the interest in physical integrity can be protected in many ways. In T1, in time one, before the harm, my interest in physical integrity justifies imposing on everyone else a duty not to harm me. But in T2, in time 2, after the harm, the interest that I have in my physical integrity does not justify a tort law response as the unique response or the sole response. Because other alternatives, as we discussed also yesterday with Felipe, might give you better results protecting my physical integrity, giving me prompt compensation or medical treatments or whatever. Compensation fund can provide maybe a faster attendance or faster care for the victim than tort law. In Keating's explanation, tort law is just contingently useful and a highly intuitive way to guarantee everyone a safe environment, but has no distinctive value. And of course, this is only a problem for Keating's theory if tort law actually has an intrinsic value, and I think it has. I think that while compensation funds may provide urgent aid to victims of harm, they lack the ability to establish a framework of mutual accountability and authority between the parties. This is very Darwinian or even Goldberg and Sikorsky view, the way they view interpersonal justice. Okay? Tort law plays a crucial role in fostering mutual respect and engagement among individuals, and the possibility to engage with others with mutual respect entails the private powers to hold the other person accountable, and as tort law does, and this cannot be substituted by a compensation fund. The same problem, I think, is present in Keating's understanding of the rights continuity thesis, and I suggest that it may be insufficient to explain tort law. Rights continuity, I think it may justify a right to be compensated by someone. Okay, you have in T1 a right not to be harmed, and in T2 a right to be compensated. The idea is that the same right justifies both claims because of the underlying reasons. But I don't think this works, because my well-being in general and the protection of my interests in T1 has to justify a duty on everyone else not to harm me. But in T2, this is not necessary that I have a claim against the particular officer. Maybe the particular officer is poor, cannot compensate me. My interest might require additional mechanisms such as compensation funds. So right continuity is not, I think, a good alternative to give a good justification of interpersonal justice. There are also different disagreements, but I'm late, so I will summarize. There are different views about what are the points of compensation funds, but to summarize, I could say, look, compensation funds have very different functions, perform different functions than tort law, has a broader reach. I mean, they can be applied to things that are different from unjust losses in private interactions. And the only thing that compensation funds cannot do, they can certainly protect your interest, no question about it. So tort law is not necessarily for that aim. The way in which Keating represents the central aim of tort law does not make tort law necessary at all. It is just one instrument, and empirically it can be a very poor instrument to protect our well-being, our interest. Maybe compensation funds are much better. When you put all the things together, then you get a picture in which strict liability, which is prominent in our current tort law, in all at least liberal societies, we have more cases of strict liability. Well, they don't entail a duty not to harm, and this fits has not a perfect fit with the idea that the priority of right over repair is like the central principle. And finally, there is no need of tort law to justice writ large. And I think this is a problem because from the liberal perspective, it's important to be able to relate to others and to have the same powers to hold others accountable, etc. And this can be defended from Darwinian point of view, as I said, but also from different points of view, such as Martha Nussbaum or Amartya Sen, when we have a relational, the ability to relate to others with equal standing and the social basis of self-respect, etc., etc. You can make an argument in that line, and in that way, you will find, through that path, you will find that tort law is not replaceable. It's not replaceable because there is nothing, no institution can give you that equal power to hold others accountable than tort law. Okay, I leave it here, and I apologize for the time. Thank you.
Thank you. There's a lot there, and it's very meaty. So I guess I'll go in reverse order. Starting on compensation funds. First, I think when you think about the correlativity of the duty, we have a pretty relaxed notion. That is, in almost all tort suits, payments come from insurance companies. And it's reached the point in the United States where doctrine is now distorted in the sense that there's very little development of intentional tort doctrine because everything has to be cast as some kind of negligence claim. This has been going on for about 40 or 50 years, and it's because payments come from insurance funds. And I'm not objecting to that, but when you think about that, I think it means we are attenuating the requirement of sort of the duty end of correlativity, because if we really thought this was about personal accountability in a very strong sense, we might not be willing to let you even insure against your losses because you're the person who harmed me, therefore you should make me good. And the fundamental reason that we do permit insurance is that victims would go badly undercompensated and their harms would not be repaired if we didn't, which says to me that the interest of the victim has priority in that relationship, and that we don't care about the duty end of it as much as we do care about the right end of it in terms of if you want to pick versions of continuity. And then the other, on the compensation funds, I want to say that compensation funds aren't necessarily relational, but they can be relational. That is, compensation funds can just be pure insurance funds, like you can purchase earthquake insurance in California, but because it's hard to provide, the government subsidizes a ton of earthquake insurance. So you can see that as a government subsidized compensation program. And it's certainly not against a wrong because you can't, impute wrongs to Mother Nature for seismic events. However, I think that if you think about the history of enterprise liability in the United States, but also the normative argument that Waldron makes, which you can see is a version of enterprise liability that can be best expressed in administrative schemes because they can set out coordinate responsibilities appropriately, that is relational, but takes the object of relation to be the community of risk, so that the fundamental force of Waldron's critique, and you're right to say he's using a negligent driver example. It's much easier, I think, more manageable in the auto context than the strict liability ones are, because it's difficult to know how to solve the Coasian problem of why we don't have just a joint cost with if there's no fault. But the fundamental fairness complaint he has against negligence is that fate and fortune acted in the same way, and one is going to be devastated by the liability and the other is going to get off scot-free, and that is unfair as between the two of them. That idea of unfairness, which I agree with, is more than corrective. Like, it says there's a retributive element there, I think, folded in there. But then I don't think our institutions like tort law are pure in the way that you might imagine in some theoretical, like Canadian accounts of tort law. And so it's the fairness, one of the fundamental justifications for shifting away from negligence in that account is that it's unfair among the treatment of similarly situated injurers, and that the proper form of just relations among the community that both imposes and is exposed to the risk is a form of responsibility that distributes a kind of commutative justice or local distributive justice that distributes the costs of particularly unavoidable accidents across the community. And so I think that is a form of relational justice. It's a form of relational justice that says, given that we can, I think, generally flip back and forth between activity and action, or act conceptions of liability in our world, it says we really ought to understand the problem we're dealing with here as the social problem of accidents. And I think modern American tort law really does take its form in the late 19th century as a response to industrialization, and it pushes the intentional torts off to the side and puts negligence as a response to accidents at the center. It's because they're a social problem. And that doesn't mean all moral questions of relations among persons vanish. It means that the moral questions among relations among persons step up to ask about at what level of community should we assign responsibility. And systems of enterprise liability start with small notions, workers' comp are just firm level, vicarious liability is just firm level. You can spin all the way out to society level just by in New Zealand, by letting that idea run. But I think you still have a relational idea of responsibility for each other's fate. In fact, I think you push pretty hard if you adopt a certain idiom that there's an affirmative sense of owning responsibility for each other's fate that is badly missing in libertarian Anglo-Saxon, tort law that just has too strong a notion of negative responsibility. Well, if it wasn't me who personally injured you, what does it matter that just as well might have been me, but for the grace of God, as the person who did, my hands are clean and yours are dirty, and that's the end of it. I think there's a powerful case to be made that the notion of interpersonal responsibility that is expressed in enterprise liability is at least as compelling as the notion that you could take more individualistically. I think most of our other disagreements, they have two aspects. One is about strict liability. Another is about this question of, I think it's about duty-right correlativity. And I think there's a sense in which my account of strict liability does, I don't know if I can go so far as to say jettison duty-right accountability, but it doesn't give it a strong interpretation as your understanding does. And I think that's because I want to pry apart things that I think get collapsed if you make duty-right correlativity as a formal principle, as strong a principle as in the account you're offering. And one way into that is to think about the Boomer case, which is the canonical American case on nuisance in the latter half of the 20th century. The Boomer case is like a classic nuisance as modern pollution case. It's a cement plant in upstate New York. Cement plant, unsurprisingly, spews pollution and cement dust, and it's situated next to a bunch of, in a rural area, so there are farms, and it interferes with its neighbors' rights to the reasonable use and enjoyment of the property. And what happens is New York had a traditional rule, which was if you can establish a significant nuisance, it has to be a substantial interference, but once you cross the threshold of substantiality, the traditional New York rule is injunction as a matter of right. And in the Boomer case, that would have meant shutting down the cement plant. And what the cement plant said was, look, we're taking all feasible precautions, not like just efficient precautions. We're taking all feasible precautions, state-of-the-art precautions, to reduce our interference with our neighbors through the stuff we spew out in the way of pollution and dust. The only thing we can do at this point to reduce it is to shut down. And the court, if we want to think of it this way, blinks at that one and says, we're going to repudiate the damages, the injunction as a matter of right rule, and adopt damages as a matter of right as our rule, and you get injunction on a showing that the activity should be altered. That is, that in some way more care should be exercised. So if we come back to the question of duty not to harm as opposed to my account, which I think you're not the only person who reads me as collapsing into a sort of market deterrence thing, but I don't think the position is that. The position is it's strict liability is more stringent than negligence. Negligence requires reasonable precaution. Strict liability requires take reasonable precaution, but when there are residual risks, you're responsible for repairing the harm done by the residual risks. But it doesn't call that a duty not to harm. And the reason for not calling it a duty not to harm is there's a big question as to how do you differentiate duties. One account is that duties are going to be differentiated at the end of the day when you cash things out and work your way through some gnarly problem by the actions they require. That's Raz's position, and it will work as a default. And here, I think we know what to require in the way of duty if we want to stop the harm of the cement plant. The answer is shut down the damn cement plant. And we don't. And the reason we don't is because we say in an industrial society, we need to, you know, it's the, you need the eggs, so you have to put up with the chickens. And so we permit the interference with the right, and there are rights on both sides of the equation. That is, it's the cement plant's right to the reasonable use of its property against the neighbor's right to the reasonable use and enjoyment of their property. And we reconcile them by saying permanent damages as a matter of right for the interference. But only go to injunction if we're prepared to demand as an action shut down the activity. So I think there's a paradoxical quality to the statement of a duty not to harm as justifying strict liability, because what strict liability addresses distinctively, I think, in American law, I can't speak to other places as much, but is harms that will persist even after all reasonable precautions have been taken, and where we don't demand more in the way of precaution. And this is also salient in some Central American blasting cases. So there's a leading early strict liability for blasting case where the problem is that somebody's building a hydroelectric plant. It's in the Vermont-New Hampshire border, which is granite, and the only way to build a plant is you got to use dynamite. You cannot move granite without using dynamite. And you have to store the dynamite somewhere, and you have to transport the dynamite. And the dynamite is just intrinsically unstable. That's why it's a great explosive. So even if you take all reasonable precautions, it doesn't always work out. And it blows up and does property damage and kills some people. And there's a discussion of the possible precautions, and the basic problem is you could have stored the dynamite closer to the site where you would transport it shorter distances, but that inevitably exposes it to a more densely populated area. So if you keep it further away, you have to transport it further, and the transporting process is just itself risky because it jostles the dynamite and that could cause it to explode. And so there's no precaution that will reduce the risks of dynamite down to the court's intuitive sense of the normally acceptable level of risk of a normal activity, that, like driving, which is a very dangerous activity, but it's normal. It's just going to be, no matter what you do, there's going to be more risk. So the court isn't calling for increased precaution. The court isn't saying alter your conduct so as not to inflict harm. The court is saying, even though you exercise all reasonable precaution, you're responsible for the harm. And so I want to explain that, and this is where I think you gain something and justify it, explain and justify it by prying apart the correlativity of duty and right in your framework by saying, what really justifies this is the intrinsic badness of harm. It isn't what's wrong with the conduct of the cement plant in Boomer. We're prepared to accept the conduct because we believe we just need industrial activities, and if we reduce them to the lowest feasible level of harm they inflict, we have to put up with them. In the same way, it isn't the conduct in the blasting case I'm describing, because we think there isn't anything they could have done that would have made it safer. We think that the intrinsic badness of harm requires compensating people in this kind of circumstance. And then the big question becomes, so what separates domains of strict liability from domains of negligence liability? And it's some variant on normal activities in the United States get subjected to negligence liability, and perhaps one explanation for that is the residual risks of normal activities are distributed reasonably justly because they fall kind of randomly on the same population, since people are both equally injurers and equally victims, at least in an ex-ante sense. I'm not in love with that explanation, but it's a salient one. And the other is to explain how you go from there to enterprise liability. And the answer is there is a relational aspect between enterprise liability, how it is that the activity of the injurer affects the rights of the plaintiff. It's because what demands can the victim make on the activity or on the actor who inflicts harm depends on what the capacities of the actor who inflicts the harm are. And in the world of activities, it's possible for the actor who inflicts the harm to distribute the cost of the harm. It cannot be avoided. Now, I put it somewhat provocatively, but I'll come back to Vincent like here and defend it as should not be, but should not be in the sense that you should not be taking more precaution because we think you've exhausted the realm of reasonable precaution. That it's still possible for the injurer in the world of activities, unlike the pure world of acts, which is a 19th century world where there isn't the possibility of distributing across the enterprise, to distribute the cost of the harm fairly across the enterprise. And so then, here's what I think is the connection between harming and wronging. In defining what I think are the salient elements of strict liability, or what I'm calling harm-based strict liability, as opposed to sovereignty-based, it is a conditional wrong. It is the case that you're only permitted to conduct certain kinds of activities if you take all reasonable precautions and then compensate the victims that you harm for the harm that you do to them. That's a characterization of the form of the activity. And then if you say, what's the wrong? Well, the wrong is you're exploiting them because you're sacrificing them to the beneficiaries of the activity, and that's unjust. Now, it's true that the best way to not sacrifice them is not to harm them, but we're not willing to stop the activity. And in fact, there, or at least an assumption here, there is no other way to avoid the harm in the long run or from the activity. It isn't the case, and I think it's different here from your description of the ordinary auto accident. That's a lapse, and we do know that statistically everybody's lapse prone. Human beings are very lapse prone. this is why we're always being sold autonomous vehicles are going to be far superior in a hypothetical world in which they don't have other faults because they're not lapse prone. And so negligence liability makes the judgment we're all responsible for our lapses. And that's not what's at stake in these forms of strict liability. It isn't a lapse in Boomer. It isn't a lapse in the blasting case I discussed. It is the unavoidable consequence of conducting the activity. So it is a different wrong that responsibility is attaching to there. And we could implement our principle more stringently by stopping the activity, but we're not prepared to do that. So I think what that brings me to then is to how should we think about Vincent? And Vincent is a complicated case. It's also, it has the following weird quality. I've not done this myself, but I once read an article not so long ago where somebody said, you know, Vincent's only been cited, did a Lexis search and said, in the United States, it's only been cited by 12 other cases, but it's been cited by 300 or maybe it was 500 law review articles, okay? So this is an unusual and case that can be understood in a variety of ways. And so let me approach it from a slightly different way from either you or I talk about it and then come back to it, which is, some people think what their concern with Vincent is it's a duty to rescue case, all right? And officially in Anglo-American law or in American law, there's no general duty to rescue. There have to be quite a few exceptional duties, but there's no general duty. And so some people are affronted whenever they see a duty to rescue. And how do you think of Vincent as a duty to rescue case? You think, well, the dock owner just has to make their property available to the ship owner. And that amounts to being required to assist the ship owner in saving their own property, okay? And I think, by the way, although the Toronto school doesn't put its concerns this way, that really resonates with the Toronto school's concerns because their conception of tort law's fundamental concern and their understanding of property rights in there is that everybody gets to be independent and you don't get to enlist somebody else in your projects without their consent, and hence this kind of objection that the dock owner is being enlisted in the project of the ship owner just because they're available and without their consent resonates with the Toronto way of talking about this. So why introduce this further complication in Vincent? Well, partly because I think it's a question of thinking of what right is at stake in Vincent. And one of the things, here are two rights that might be at stake. One is you have a kind of sovereignty right, which is just to control the use of your property. You get to decide how your property is used, and if you don't consent to somebody using it in a certain way, they're violating your right. The other is, well, it's my stuff and you can't damage it. I think only the second right is at stake in Vincent. And the reason I think that is because the court says the circumstances that trigger the application of the doctrine of necessity suspend the normal operations of rights. And I think what the court is saying is suspended is your sovereignty with respect to your property. It is not a trespass for the, you don't have a basis, John Goldberg puts this in terms of limiting the right of self-help, but I don't think that goes far enough. You couldn't object to the entry of the ship owner onto the dock. And the entry happens when the ship owner does tie the ropes because the ship owner's overstayed its period of time to dock under the contract, so it no longer has consent. Well, you can't because that right of yours has been suspended. So what remains in Vincent is it's still your property. And I think the moral intuition in Vincent is the intuition that the ship owner is entitled to save their ship because they're entitled to act reasonably to save their ship, but they're not entitled to turn the storm from their problem into your problem, which means that's why they have to undertake the reparation. And so then coming back to things that relate to the continuity thesis there, I think a salient feature of certain ways of talking about problems in this domain, John Gardner is very powerful in this, but it can be misleading, is that there's always residues. There are residues from certain kinds of actions because you do the all things considered correct thing to do, but there are undefeated reasons against what you do, and that leaves a residue in some form. And that description fits tragic choices very well, I think, because there are tragic choices where no matter what you do, you're going to leave some value on the table, or you're going to have reasons you couldn't satisfy. I'm going to say I don't think it fits that Vincent at all right? In Vincent, and this is where efficient precaution comes in, it's not because I have a market deterrence theory, it's because when all you're dealing with is commercial property, the relevant reasons are commercial efficiency reasons, which is once you've said we've suspended the right of the owner of the dock because that's the effect the storm has on people's rights, it simply suspends the operation of normal rights, then what we ask of the owner of the ship is that they act really reasonably prudently, which is efficiently. And the reasonably prudent way to act is to save your ship even if it does some damage to the dock. But fairness says you shouldn't transfer that loss to the dock owner. But once we've taken care of the fairness concern, I think there are zero residual. We shouldn't be thinking like John Gardner that there's just always some residual thing that's going to dog us, and you need to see your therapist because you did wrong, even though you did right, and you got to work it all out with your therapist or whatever. I just don't think that's right in Vincent, and I don't think that we are interfering with a legal right that you have in this circumstance, that we not interfere with your property. So that's my view of Vincent, and about now it may be a very, very specialized case, but it isolates something very interesting, I think, which is it isolates a circumstance where there is a defeat of the right to control who enters your property, but you still have a claim that your property shouldn't just be sacrificed for the benefit of the person saving themselves with it. It's a case where the correct level of precaution isn't that demanding, it should just be efficient. But it does require reparation after the fact in order to respond to concerns of fairness. But when you've done those things, you've simply actually satisfied all the relevant values. There isn't anything else you should be trying to satisfy, in my opinion. And so maybe then I should talk about sovereignty. And to some extent, Moore is not a perfect case for me, though it's a famous case. But here's how you might think about sovereignty torts as conduct is not wrongful. There are other sovereignty torts, I probably didn't mention them, that involve trespasses. And trespasses are unlike batteries in the sense that in batteries, unless you're on psychotropic drugs, you tend to know when you've made contact with somebody else's body. But often you don't know when you've entered someone else's property, and you actually couldn't reasonably know, because the only way you could know was to hire a surveyor. It wasn't possible to hire a surveyor before you made the mistake of entering somebody's property. And that's a trespass under the common law. And one way to describe that is to say, well, if we look at that morally, we would think you did the wrong thing, but you're excused. We wouldn't think it was justified, but we'd think this is entirely innocent. You're entitled to an excuse, morally speaking. Nobody should blame you or think badly of you because you did that. Another way to think of it is to put it in terms of Derek Parfit's distinctions between negligence is generally an evidence relative wrong. Here, relative to all the evidence, you behaved reasonably. And that's not true in negligence cases. The key thing in a negligence case is you behave unreasonably relative to all the evidence. So that's what I mean when I want to say the conduct is not what drives the wrong in a sovereignty tort. And in the particular case of Moore, which is an 1890 case of battery, somebody has a diseased ear. It's not possible to determine what the disease is until you start the surgery. The surgeon goes in and says, oh, I thought it was the left ear, but it's actually the right ear. Fixes the right ear, doesn't wake the patient up and get the patient new consent. Has perfectly good reasons, one thinks, for that, which is this is dangerous, particularly dangerous in 1890 with anesthesia and so on. And the patient is consenting to having their condition cured. And the court is a stickler and says, no, you got to have a bright line for touching people's bodies. So I don't think we think, even though in the abstract we describe, clearly it's wrong to touch somebody's body in a medical operation without their consent. This is a very excusable mistake. We would not fault that surgeon very much, even if we think they should have behaved differently. And so I think it's very different from negligence in that way. And the reason it's different is that you don't have the kind of power a sovereignty tort protects if you only have it against unreasonable invasions. I mean, none of us would really want to have our rights to bodily integrity depend on the touchings can't be unreasonable. At least in a multicultural society, that could be an extremely complex determination, and you might have to live with touchings that you thought, I really don't like this at all, but it's not considered unreasonable by the mores of the community I just bumped into on the street today. And in the same vein, you won't have your power of dominion over your own property would be compromised if any reasonable trespass wasn't a trespass. So that's what I think sovereignty torts are not fundamentally about conduct-based wrongs, because it's not the wrongfulness of the conduct that attracts the liability. It's the importance of protecting the power of control over one's person or one's property that attracts the liability. And then coming back to, I think the common thread, although I think you're skeptical of this, the common thread here is thinking, if you think about strict liability in the way I'm thinking about it in cases like Boomer and Abnormally Dangerous, you bring out that harm has this intrinsic moral significance because it's intrinsically bad for persons, because it seriously impairs their powers of agency in ways that, like losses in your example of fair competition, don't in general impair agency in the same way. And there's a connection between harm and impairing powers of agency and sovereignty torts, which is when you just trespass harmlessly, what you do to me is take control over something that's supposed to be under the control of my will. And that's the connection. Harm is in its core instances, it impairs my will, because my body is what I use to assert my agency through. And if you break my arm, or Sylvia breaks her hand on a bike accident, she can't type. That's an impairment of your agency. And if you enter my property or take control of my chattel without my permission, you thwart my will, and you can trace them back to a common root. And so I think I probably do lose a certain elegance at the level of formal correlativity. I don't think I lose relationality, because I think you can explain these things in relational terms, even though some things like compensation schemes can be non-relational. You can explain the ones that I care about in relational terms. You can explain the relation of an activity to the rights of a victim in relational terms. You can explain sovereignty torts and the relations to entry to persons who touch or enter your property in relational terms. But I think you lose a certain kind of formal correlativity. But the advantage of that is I think you can bring out that we care a lot about harm. And this may just be where I am departing from the sort of strict Kantians for whom harm has no independent significance.
That's it? Okay, perfect. Thank you so much to both of you.
That was a very long
Thank you so much.